I'm going to go on the record here. I just want to ask it, how many days are we talking about of information that are here?
You mean how many instances, Judge?
Yeah, I guess not days, but like exchanges is really, I guess, the question.
Five, Your Honor.
And these exchanges were all part of discovery?
Absolutely, Your Honor. They're also within the time of the charging period in this case.
Okay. Is the intention to go through each one of these pages?
The intention, Your Honor, and that's why I provide this summary, is that I provide the data from the cell phone extraction so that they have that and they can verify it with their own records, which is helpful, I think, when we're doing summaries, especially with how the statute's written. And then the summary pages that are in the much easier to read tables would be what I would publish to the jury. It's a summary, and that's the date and the time, but it's made easier for everybody to digest so that we can get through it much more quickly. And so
it looks like there's at least 117, 118 through 125. Is that right? Okay.
yeah, that I thought you were speaking specifically, Your Honor, to 117. There's also timeline information from the phones related to the 10th and the 11th that I intended to get into as well.
We might as well address all. Is there a summary on these other packets?
No, Judge. If there's not a summary, it's my intention to just ask Sergeant Amundsen about specific instances in those. I provide the bigger part of the exhibit just so, again, Attorney Zacher and the defense team have the context of things, and so the whole record's provided.
Okay.
That's the issue, Judge.
All right. So really, we're only talking about 117 here is the issue. 118, and I don't know if you have an objection, 118 through 125. Those look like packets of information that was, it looks like 126 and 127, 128. Is that correct?
Yeah, 125 is a summary document of 124, again, so that it's easier to read. The other issue that I think we were struggling with when Attorney Zacher was presenting Facebook images or messages, Your Honor, is that it's in the universal time code, and so we're saying things like subtract about 5 or 6 hours wherever we are with daylight savings, and I think that's confusing to the jury and to the witness. And so not all of these are exhibits that I intend to publish, but it is information that I intend to go through.
Okay. Mr. Zacher.
Well, Judge, the problem here is that these are documents that were altered and generated by the state for the purpose of production at trial. A statement of Investigator or Sergeant Amundsen here.
What statement?
You're offering these as his statements.
I'm offering them as exhibits that are coming in through him, just like the
exhibits that are coming in through him that have been altered by the state and presented as evidence.
They're Ms. Dikeman statements.
It was not presented to us before trial, Judge. This is a discovery violation. 971-23-1, parent AM. A relevant recorded statement of any witness on the state's list. it also contains evidence of other acts that were never introduced or litigated, despite the fact that we have a motion in limine agreeing that the state would not be introducing other acts unless they were pre-litigated, particularly incidents where the state is attempting to paint Ms. Dikeman as a pill distributor or somebody who was receiving pills unrelated to this case. Oxycodone, or whether or not she got pain medications from her mother after Mr. Pedrin beat her, mind you,
That's an
are not
allegation.
relevant. Are not relevant at all. Like, show me how this is admissible under Sullivan. The statements themselves that the state is also going to be introducing, it's hearsay. We've got statements from Becky Ehlers. We've got statements from Mr. Pedrin. I haven't been able to cross-examine or confront either of them. This is far too little, too late. It should be excluded.
What exactly is the information that Attorney Zacher didn't have prior to today, Your Honor? If he looks at these summaries, and you're allowed to produce a summary as long as the entire record is available to defense counsel so that they can verify the accuracy of the summary, that's allowable. This is all information he has. It's in a form so the jury can digest it.
And I don't know, my objection was the same to Exhibit 116, which grossly misrepresented the number of days that Alexavier was out of school with excuses.
Doesn't matter for truancy. The school keeps track of it the same way.
All right. Let me ask this question. The parts which are not the summaries, are those accurate? Are those things you had?
We have these records, Judge, but I disagree that either the summary or the, in particular, some of the content of this summary is even admissible. I think that this is unnoticed other acts. It serves no relevant purpose. It's dramatically outweighed by the prejudice to Ms. Dikeman, tending to paint her as a drug addict or somebody who procures pills when this was never litigated once before trial.
Your Honor, it also goes to the other acts that they are putting at Mr. Pedrin, right? We saw all those videos where he's like, you use pills. She's like, no, you do, right? The jury is allowed to have information to determine whether or not those other acts were proved to the necessary standard. There, again, is nothing in these statements, these summaries, that they didn't previously have. It's within the time charge period, or the charged period here, Your Honor. So
the state should have noticed this as another act and brought it up with Mr. Pedrin while I could confront him on the stand about those statements.
I can't. They're not his statements. He wasn't involved in these messages between Ms. Ehlers and Ms. Dikeman. Your Honor, her attorneys are representing, right, her as somebody who successfully completed drug court, and especially in comparison to the evidence that they presented regarding Mr. Pedrin. Like,
she did successfully complete drug court, Judge. And
Wait, just give me a second, okay? For God's sake. So the problem I see is this, is I don't know what they're referring to in these things. I don't know, 10 pills, 3 pills, whatever it might be. It's not clear what they're referring to.
prescription pills.
No, I understand
Okay.
that. I understand it's prescription pills, but the reality is it Xanax? Is it oxycodone? What is it? Because I assume it's for pain medications or vice versa.
Attorney
Xanax
Zacher, excuse me, Your Honor, but Attorney Zacher said, I believe in his opening statement, that she was getting these pills from her mom because she was being hurt.
Yeah.
So he's acknowledging, right, that they know what kind of pills they are. I mean, I know we can't drag this out, Your Honor. I know that, but if I understand.
I was told yesterday that, no, our director won't take that long. We're more worried about Mr. Zacher's. Right now, Mr. Zacher's not going to be starting until about 3:30, 4 o'clock at best. And the state has taken all day. So I'm going to give you a choice. One, you can use 1 or 2 of the, I actually think 117 looks like that's related to those pills. I get that. The other ones, I mean, the other ones, are you objecting to 118, 117? Damn it.
Yeah, and Your Honor, the first one on 117 already came in, the comment about getting Xanax, so.
And Judge, I agree that that's probably relevant context evidence, that text about the Xanax. Where my objection lies is all these texts about, well, oxycodone or anything else.
Attorney Zacher represented she's getting it because she's being hurt by Mr. Pedrin. What she's representing to her mom in these is that she has different ailments, and it isn't for that purpose, Your Honor. So I think it goes to her credibility as well.
We talked about the hydrocodone texts that were recent to the allegation. I didn't talk about anything else.
They're all in the time period that these charges were contained in the criminal complaint.
I mean, just a second. I'm going through these summaries. I don't even see the word oxycodone. I don't see. I'm just going through your summaries, right? That's what was actually said in these.
Judge, people who are trading medicines don't put the kind of medicine they're buying in this, right? We had this script text related to Mr. Pedrin.
So, but then it's pure speculation about what the actual drugs are, right? We don't know what the drugs are because you're not, this is, except for the Xanax response. But the rest of them are, do you have 9? Do you have 2? Do you have 10? Are you going to the pharmacy? I mean, you're giving me about 4 minutes here to review this, so I don't,
Judge,
if I'm misquoting it, I'm sorry, but.
I don't think he has a proper legal objection to this, except he doesn't like it.
I've stated my itemized objections repeatedly.
Yeah, that this is a discovery issue, this should have been turned over, so we're
Judge,
not
how is
gonna.
it a discovery issue? I would like a ruling on that because, Your Honor, I have other messages. We're gonna have a cross-examination next week. I would just like.
We're gonna have cross-examination next week?
Judge, what do you?
All right, Dahlia, I want to take about a 5-minute break. Let me think about this. I don't even know. To be honest, yeah, give me a 5-minute break, okay? You think about how this should go.
And then we're cross-examining witnesses next week.
Maybe seated. Okay, first of all, on the issue of 117, 117 is a summary of exchanges for it looks like it's mostly Becky Ellers. Is it all Becky Ellers, I think? Exchanges with Becky Ellers. The statements by Becky Ellers are hearsay. First of all, on the issue of discovery, this was turned over. I do believe the state has the ability to make a summary. The problem I see more is the issue of hearsay in these. You know, they're not being offered for the truth of the matter, but there are statements that are being stated by Ms. Dikeman, which are being offered for the truth of the matter to prove that she's involved with getting certain types of drugs from her mother, and these are prescription, they seem to be prescription drugs, to be honest, and not highly things. So this is what I'll let you do. I'm not going to let you use the summaries. I'll let you use that. You can say the dates and the times of what Josie Dikeman said in these to avoid the hearsay situation. That's what the current situation is. Because I think otherwise Ms. Ellers was going to be, should have been able to testify as to what she said.
Then, Judge, we can call her.
All right?
What you would prefer? I think her statements give context. I would note that.
They're not being offered for the truth of the matter, right?
Absolutely, Judge, just like.
But there's a whole, like January 19th, there's one phrase by Ms. Dikeman. The rest are responses by Ms. Ellers. So you cannot be offering the last three because there's no, it's the effect on the listener question, right? Did this listener, this is not being offered, it's giving context for this.
Your Honor, but
Just have 1 second with Ms. Rude.
Yeah, go ahead.
Your Honor, about the 19th, I hear what you're saying. I think, though, the context actually comes from the messages a week later where Ms. Dikeman says, Mom, do you have a couple more extra I could buy? I'm not doing good with this COVID. Right? And both times, it's Mr. Pedrin going to get the medicine. Or I would note the one that's around the May date, Your Honor, coincides with the prescription label of the oxycodone that Sergeant Amundsen testified to today. So I think that also gives context to that. I didn't put all of them in, Your Honor, that were within these records. I tried to be selective.
No, I mean, I understand you're trying to be selective, et cetera, but you have hearsay here. You're trying to tell me it's being offered for contextual reasons, but you're not calling Ms. Ehlers to bring this on with Ms. Ehlers. But, you know, I think that's the problem with this, that these are exchanges between Ms. Dikeman and Ms. Ehlers, and yet I understand you're trying to speed it up with the investigator, but it seems to me that this is if you want to get into what the content is by Ms. Ehlers, you got to have Ms. Ehlers testify to it.
Then, Judge, will you strike the testimony related to Mr. Pedrin and the script and the unknown person that they provided that evidence related to?
There was no objection at the time. It was a valid hearsay, except not tit for tat when it comes to these. I made the objection, the state did not.
I'm seeing what I have in front of me right now. I'm not.
I know, but I understand what something not being offered for the truth of the matter means. So that's my frustration, Your Honor.
Judge,
And I think the objection was made at that time, Your Honor, and it was said that it wasn't for the truth of the matter asserted. Context.
Okay. 117, you can use Ms. Dikeman's quotes. You can use the what I will allow them to be is you can say, you can have Investigator Amundsen talk about what was said right before it and then what was said. So there are some that sort of an exchange back and forth. But there's a whole nother series where, I mean, the very last one in theory is about a vape. It's not even about drugs.
No, Your Honor, that is Ms. Ehlers asking that Derek pick up the vape on the way to pick up the pills because she's at work and she needs her vape.
That seems a lot built into that statement. I'm sorry, but
I am too,
text
Judge.
messages are laden with, you know, we don't know exactly what was said. That's why hearsay becomes a lot more difficult to start adding and applying inferences to what it's being said here. People have inferences being said, and it could be wrong. It's speculation as far as I'm concerned. I mean, actually, that last exchange, she talks about a vape. She doesn't talk, at the very end, she talks about a vape. She doesn't talk about pills.
Ms. Ehlers talks about the vape being brought to her.
Right. I mean, I don't know. Okay.
Judge, I would note that this packet contains exhibits marked through 128. My objection is the same to all of these proposed exhibits.
Well, 118 looks like, this is just a Cellbrite, from what I can tell. That's
All Cellbrite or Facebook data.
Okay, so but this is not, it's just a section taken out, right?
What is, Your Honor?
The Cellbrite, 118 is Cellbrite data that was taken out of the discovery.
Correct.
or out of what you got back on the search warrants, or from the, actually not a search warrant, but it's from the download.
I'll save you the trouble. No objection to 118.
What about 121? I don't know where 119 is. I may have misplaced it.
I don't have a 119 in here.
Okay. 121 looks like to be the same thing. Is that correct?
Well,
It's
it's all Cellbrite information. They contain different parts of the Cellbrite data, Your Honor.
Right. So 121, just let's go through this so we don't keep on having continuous objections. So 121, 122, and 123 seems to be Cellbrite data. Is that correct?
Yes.
It's Cellbrite data, but looking at 121, it's a complete mix. So we've got web search history, we've got call logs, we've got instant messages, we've got text messages. It's still rife with hearsay. It's rife with irrelevant content.
I'm not offering all of it, Your Honor. I offer these when I give them to counsel prior to me beginning questioning, so they have a minute to look at that. I like to pre-mark things and be prepared so that we can hopefully move through things more quickly. I provide these for the context.
Hold on.
I know, so there are certain things I'm going to go into on each of these exhibits. I'm not going into everything
Right.
on them.
So 124 looks like Meta Platform business records. So that's another, that came probably from a search warrant of some sort. It's 125, that seems to be, is that some type of composite log? Or is that from Meta Platform records?
125 is a summary of the meta information in 124.
Okay.
And again, part of the reason for that is so that it has the accurate time frame when the witness is testifying to it.
Right, that's correct. I see that. And do you have an objection to that?
Judge, more than half of this is hearsay from Mr. Pedrin.
Were you going to go through each one of these
No, Judge.
exchanges?
And we would be here for a whole nother week. That wasn't my intent. Again, I do this so they have context, so that I'm not presenting one message, out of a million messages, and then they're scrambling and it's taking us time to get through this stuff. So I provide all of them in context so that we can get through this if they have questions.
So is your intention to show what Mr. Pedrin is saying? Or just what Ms. Dikeman?
No, Your Honor. My intention is to show what Ms. Dikeman is saying. Sometimes it includes a statement of Mr. Pedrin, like if she's answering a question related to what I'm getting into with this exhibit. But it's, again, offered for context and not for the truth of the matter.
So 124, 125, there may be a selective objection on hearsay, but I'll take a look at the context. Those are admissible. Then 126 and 127, or is it just 126? This is the exchange between Ms. Raines and Ms. Dikeman, which has been essentially.
That 127, no objection.
That summary?
126, no objection.
Okay, 126 and 127. What about 128?
Again, as a summary of what I intend with my further direct of the sergeant to get in. So it's just providing context of the evidence that comes in. Because, right, the problem is I have to present it in these piecemeal ways because some of it comes from Meta, some of it comes from Cellbrite, that sort of thing. I'm just trying to put it in context for the jury.
I understand. I'm just trying to figure out. So 128, there are statements from Raphael, I forget it, but there's statements back to him from Ms. Dikeman. And then there's the call to 911. There's the call to her mother, called 911. I think that is contextual, but what was actually being said by Mr., forgetting his name, what's his last name?
Suarez Porfirio.
Suarez, okay, I'm sorry. I mean, do you object to any of that in 128?
Judge,
Technically hearsay.
if I had been emailed this a week ago,
Let's just tell me, do you object to it?
I don't know if it's accurate. I have to object at this point.
Right.
And Your
I'm
Honor, if I
assuming-
have to change these exhibits, that's the other part. I can't do that on the fly at this point.
I'm not changing, what I'm saying is I'm okay with 128. Yeah, I mean, I think 128 is the context of what happened right in that morning, so I don't have a problem with that at all. So what I'll say is for 117, so we're going to have to break it down because I don't know what else, other way to deal with this, is July 6th. I don't have a problem with that entire being submitted. July 11th, that's fine.
11th, Judge?
What?
The May 11th?
May 11th, 21, that's fine. October 10th, I think do not use October 10th, but you can do the first three exchanges that can just be read. Read by, what were the exchanges? 105, 115, 115. Do you see what I'm saying? Those first three? Because that's contextual, yes, what's up, and then she answers. What Ms. Ellers says afterwards is hearsay.
Can I ask a clarifying question?
No, are you following what I'm saying or not?
I am. I was just wondering if we could ask based on the context of the conversation, what was it about without putting in those other statements? Could the investigator say that on that particular dialogue?
I think it's up to, unless Ms. Ellers is here, that context doesn't, you can give this to the jury and the jury can decide if it's really relevant to drug dealing or not. Even if I let Ms. Ellers put in what she says here is, I will get home, I have your 20, I have 10 extra, I'm now at Walmart, or I'm at Walmart now, where are you? Probably about medications, but the reality is unless Ms. Ellers is here to explain what that exchange is about, I'm not sure how that is, or as Ms. Dikeman explains it. So whatever the investigator says is that it's conjecture. It's not based in what he knows about what was actually what was meant or said, because it is hearsay. It's why hearsay is excluded, in fact. So the next exchange, January 19th, I believe, is what I was on, 2023. How are you feeling? Throat hurts and back hurts. Ms. Dikeman doesn't even respond. She just says, my throat hurts and back hurts. So, unless I'm missing something.
That's the one I said was in context, where she a week later then asks if she has a couple more that she can buy.
So a week.
Says I can give you 10, and she said Derek went to pick up the kids so he can stop by you.
That's connecting something that happened in January 19th, 2023 to January 26th, 2023, 7 days later. You're saying that my throat hurts and back hurts is the reason why 7 days later this other thing is exchanged?
I'm saying it puts in context, right, when she's saying I'm calling for a refill now, it's ready, but I work until 9. I can't get it till tomorrow, but I can give Derek a couple to try. So she can't give him a lot. She has a couple because she can't get a refill till the next day.
You're making a lot of assumptions that the couple that she's starting to talk about 7 days later is the same couple she's talking about 7 days before.
She's asking for a couple more.
Couple more what? Unless you have the person saying, this is why hearsay isn't.
I understand, Josh.
Yeah. So you know what? I just don't. I'm not going to allow 19th and 26th. You can bring in the other ones as I've explained. We've already talked about the other ones. So, all right, let's go forward.
Hold on, Judge. I want to make extra certain. Are you saying I can publish the summaries for both July 6th of 2021,
July 6th of 2021.
May 11th of 2021?
May 11th of 21. It's only part of October 10th of 22.
I'm going to skip that one, Judge. We're just going to keep moving.
Okay, and I think 19th, no, and the next one, no, so it's only those two.
Judge, just so I don't interrupt the flow, I'm just going to enter a standing hearsay and confrontation and speculation and relevance objection to the remaining content, and I won't object individually.
Yeah, I don't think this is a discovery issue. I think it's more of an issue of hearsay issues and then confrontation, but I think the way I've limited that, that avoids those issues. So, all right, let's get going, bring the jury in. We'll figure it out after. I don't think it's 126. Go ahead and bring him in. You can come on up. Investigator, you can come on up.